So we're going to be looking at the Commonwealth versus Grow case. And in Grow, we have a real question of statutory interpretation. In many ways, a criminal law class is nothing more than statutory interpretation. What are the ways that the government or the state promulgates its laws that forbid certain criminal activity? It's always through a statute, or in the case of a city, an ordinance, which is just basically a statute written by a city council rather than a state legislature or the federal legislature. So in essence, criminal law is always about interpreting statutes. We really don't have any common law crimes anymore, those crimes that are basically created by judges who for the first time see something awful and then decide to punish it. Those things don't really exist in American law anymore. And so we're always going to be asking about how to interpret statutes. And the Commonwealth versus Grow case gives us a great example of how to methodically go about approaching questions of ambiguity in words, particularly words in statutes. So I'm going to now share with you my screen. Screen share. Share, and then let's start. From beginning. And there we are. So in the Commonwealth versus Grow case, we have a DUI. The defendant is in an automobile accident. The police come along, he is arrested, but he refuses to take a blood test. And so the question is, since this is his second DUI, and he pleads guilty to the second DUI, what is his punishment going to be? So we start off looking at the statute itself. There's more to this statute, but this is the germane part of it. 3802, driving under the influence of alcohol or controlled substance. Basically 3801A1 says you're not allowed to do it. And he did it. It's no more complicated for our purposes than just that. So now we come to the question of punishment, and that is the fundamental question in this case. So we learn in 3803 that if 3A1, that if you have no more than one prior offense of DUI, then you can only be sentenced to 6 months in jail for a misdemeanor. That's the limit on punishment that's described in 3803A. Now, what's interesting about this particular provision, though, it also says, notwithstanding any of the provisions of subsection B. And that's where this case is going to get thorny. In B, the statute says, any individual who violates 3802A1 and refuses a breath test, then 38A1 was our last slide, and refuses a blood or breath test, then you will be punished as if you had committed, because you have now committed a misdemeanor of the first degree. Now, why does that matter? The 3803A says, look, if it's your second offense, it's a misdemeanor and no more than 6 months in jail. Well, a misdemeanor of the first degree, we've now gotten a category of the misdemeanor, and that category, misdemeanor of the first degree, has a maximum penalty of 5 years. So we've got these two provisions. 3803A says, look, second degree misdemeanor, no more than 6 months, regardless of what B says. Come down to B, but B says second offense and you refuse to blow or give blood, the maximum is now 5 years. Which one of these things control? That's our question. What is the maximum punishment for a second offense DUI when the defendant refused a blood test? A says 6 months and it's a misdemeanor for any second offense DUI, and B says that if it's second offense or greater and you refuse a blood or breath test, then it's a misdemeanor of the first degree, and then that has a maximum not of 6 months but of 5 years. What do you do with what the legislature gives us, and why is this a problem? Justice Mundy's dissent echoes what we see in the Commonwealth's argument. She says, look, you've got to give effect to all of these provisions. Clearly, B was meant to enhance the penalty for the refusal to blow, and that penalty takes us up to the punishments for first degree misdemeanors, and that's 5 years. And then she says, as she observed, also though she notes in her dissent that yes, there's this problem with the statute itself, that Section A says notwithstanding anything in B, and B is where the penalty gets jacked for this extra violation of refusing to blow. But A says notwithstanding. She says you've got to give effect to both provisions, and that is a principle of statutory construction. And so she would say the maximum possible penalty here is 5 years, not 6 months. How do we go about figuring this out? Well, as you saw in the attachments you have to chart a course for this class, there are a number of ways we go about figuring out what to do with statutes. First of all, we know that we're supposed to enact or give application to the intent of the legislature. So if the words are absolutely clear, the words will provide our answer. So you look first at the words, and unambiguous words control construction. That's provision B. And then if we need to go further than that, we'll try to look to the intent of the legislature. Why did they enact the statute? What were the unique circumstances that led to it? What was the specific thing that the legislature didn't want to have happen again? What other laws touch on the same subject, and what did those other laws do? How did they work? What are the consequences of this particular interpretation? Is some absurd result going to follow? What do we know about the legislative history? And what do we know about other committees that might have been established to interpret this? The Sentencing Commission, for instance, might have some insight that we can learn about what the legislative intent was. So we look at a number of things about what we believe the legislature's intent must have been. We believe the legislature would not have intended an absurd result. We know that they would have intended the entire statute to have an effect, and that's Justice Mundy's point. Look, there's one provision that jacks the penalty, and the other provision says we shouldn't look at that other provision. What do we do with that? We assume the General Assembly does not intend to violate the Constitution. So if there's one construction that's unconstitutional and one that satisfies the Constitution, we assume they meant the one that's constitutional. And if we look at how courts have interpreted this statute, that's also going to be relevant. And we assume the General Assembly favors a public over a private interest, but in criminal law, that really doesn't have a lot of application. We look to grammar. There are certain rules of construction that we look to. A comma can change the world in a statute, but we follow normal norms of grammar in terms of deciding meaning. Titles can matter. The title can help us understand what each section and subsection are meant to do, and that becomes part of the argument in this case, as we'll see when we get into it. We want to construe the legislature as having done something constitutional rather than something unconstitutional. And so if we have to nullify part of the statute so that the entire thing remains constitutional, we will do that. We assume there's no retroactive effect to laws, and we assume that that there's a uniformity of law, that we construe these laws consistently with how other states have when they've used these words. What did the other states mean when they've done that? This is going to come up a lot when we look at language that the legislature will borrow from other states to decide how certain crimes should be defined and punished. We look at rules of strict and liberal construction. What does that mean? When do we assume that the legislature was doing something small, and when do we assume it was doing something big? Well, if the statute is different from the common law, the laws that existed at the time the state was created, then we assume that if one interpretation negates the common law and one would affirm the common law, unless there's clarity, we assume that the common law is preserved. And we also, and this is particularly relevant in criminal law and particularly relevant in this case, we presume that the statute, if it's criminal, is to be strictly construed in favor of the defendant if there's ambiguity. If there's ambiguity. And we won't worry for now about statutes that are subject to liberal construction, because that's not applicable to criminal law. Whenever a penalty or forfeiture is provided for for a statute, for a violation of a statute, such penalty or forfeiture shall be construed to be for each violation of that statute, not a total. So like you don't get the same penalty for one versus 10 of the offenses. And then we'll skip over a few of these, but statutes in para materia. When statutes or part of statutes are in para materia, they are in this state when they relate to the same things or other similar things. So if you have one statute that looks at a very similar type of crime and it's construed in one way, we can look at the construction of that statute. So like if within the state you have one type of drug offense that's construed this way, say a cocaine offense that's written and been interpreted to mean one thing, and you've now got a marijuana statute. The same construction the court has applied to one statute on a similar topic, we will assume will apply to another. This will come up a lot as we're trying to understand what the legislature is doing. Section 1933, this comes up in the case we have for today. The particular governs the general. So if you have a statute that has a broad sweeping thing that says, unreasonable positions will not be included in this statute, and then you have something that seems patently unreasonable, but the legislature has said it's allowed, then you can't argue that the general proposition that should exclude this particular application. If it says, we don't allow big trucks on the highway, better example, less vague. We don't allow big trucks on the highway. That's your statute. But then it says 18-wheelers not exceeding, 20,000 pounds are permitted on the interstate. You are then left with the particular answer that, no big trucks on this highway, but 18-wheelers no greater than 20,000 pounds are permitted. The particular governs the general. So if your 18-wheeler is 19,000 pounds and you've got 18 wheels, you're allowed to do that, even if someone could reasonably argue, well, there really aren't any bigger trucks than that out there. The particular controls the general in the case of ambiguity or contradiction. And this is one of the principles of statutory construction that comes up in our case today, as does irreconcilable clauses. Similar issue. You have in our case for today, 6 months is the max if it's a second offense DUI, and if it's a second offense DUI and you didn't blow the breathalyzer or allowed your blood to be taken, then 5 years is the maximum penalty. So those are irreconcilable clauses, and we learn in this provision, and this becomes Justice Mundy's dissent, if you have irreconcilable clauses in there, then the last one will prevail. And we learn in another section, these today were adopted at the same time, we learn in another section that you are to try to construe the statute in such a way that all the provisions actually apply. Hard when they're irreconcilable. Here we are, irreconcilable statutes passed by the same legislature. You look to the last one, yes, use of committee comments and reports. Final provision here. Maybe the Sentencing Commission told us something. Maybe they said, this is what we think the legislature meant. And we would look to that to try to figure out how to resolve ambiguity. Now, remember, if there's no ambiguity, we're not worried about any of this stuff. It's like when the meaning of the words in the context we're trying to apply them, when we can't figure that out, that's when we go to these rules of statutory construction. So back to our case. We know that, actually, let me slide back to the statute so we remember what it's all about. 3803A, look at that, and it says that if it's a second offense DUI, the maximum is 6 months, 6 months incarceration, and it's a misdemeanor. It doesn't tell us what kind of misdemeanor. But B4 says that if it's a second offense DUI and you refuse blood or breath testing, then it's a first-degree misdemeanor, and that has a maximum penalty of 5 years. Huge difference. So now we've got to use these principles of statutory construction to try to figure out which answer is right. Is it 5, or is it 5 years, or is it 6 months as the maximum penalty? So we've seen Justice Mundy's position already, that you've got to give effect to every provision in the statute. The majority, though, says 6 months is still the maximum for this particular crime, even if you refused the breathalyzer. The majority is saying that 6 months for a second offense DUI is the most you can get, even if you refuse the blood or the breathalyzer. And here's how it gets there. It looks at all of the argument. First of all, it says, look, there's no ambiguity. It says, look, it says, Section A says, notwithstanding anything B says, if it's a second offense DUI, your maximum exposure is 6 months. Period, paragraph. But because the judge in this case is a good lawyer, he also says, but look, I'm going to address these other issues. And so what are the other issues that are raised? The first one is Justice Mundy's point in her dissent. Results are to be construed to avoid absurdity. And what would that absurdity be? The absurdity would be that Section 3803B4 has no meaning, because it specifically says second offense DUI plus refusal equals maximum possible of 5 years, not 6 months. Second argument the Commonwealth makes, if the two are in conflict, they're to be construed to give effect to both. Third, if there's any conflict at all, and it's kind of hard to argue there is no conflict here, and the conflict seems to give rise to some type of ambiguity. The argument is that the specific governs the general. What is the specific? The Commonwealth would argue that the specific is the provision that deals with second offense plus refusing the test equals 5 years. That's the specific. The general is, look, generally you don't get more than 6 months, but in the specific case you do get 5 years. Can't have big trucks, but you can't have 18-wheelers less than 20,000 pounds. The specific governs the general. That's the Commonwealth's argument. And then the Commonwealth also says, look, 3803B says other offenses. 3803A says, says notwithstanding anything in B, the offenses up here are punishable only by 6 months. That B actually adds a whole and injects something brand new that's not covered by A. This is a tougher argument. I'm almost struggling to try to make sense of the state's argument in this case, but we'll come to it. All right. So how does the majority respond to all of this? The majority says, as we've talked about, look, these things are not in conflict to begin with. There is no absurdity. There is no irreconcilable difficulty here. We're not negating anything in B by saying that even if you refuse the breathalyzer or the blood, that 6 months is still the maximum penalty. How does the majority get there? Well, they say, look, the penalty can still be a first-degree misdemeanor and have a penalty, or it can have a definition of a first-degree misdemeanor, have a classification, a gravity of a first-degree misdemeanor, but still have a penalty less than the maximum otherwise provided for a first-degree misdemeanor. The legislature, the majority says, could perfectly well say, look, this is still a first-degree misdemeanor, but in the case of second-degree or in second offense DUI, the penalty will not be the typical 5 years, but will be only 6 months. Now, why would that not just nullify the entire effect of making it a first-degree misdemeanor? Well, the court says there are other consequences other than jail time that flow from this being a first-degree misdemeanor as opposed to other lesser degrees of misdemeanor. Those things include your prior offense score the next time you're convicted. They also include the amount of time for which your license will be suspended. If you're convicted of a misdemeanor DUI and it's not first degree, your license is suspended for 12 months. It's 18 months if it's first degree. So there is a consequence to having this as a first degree misdemeanor for the refusal to blow, even if, or give blood, even if that difference is not manifested in the sentencing, even if it's a maximum of 6 months for all second degree, second offense DUIs, even if that's true, there are consequences to it being labeled a first degree misdemeanor in Section B. Let me hit that one more time for you. Just because the jail time doesn't go up under this statute, according to the majority, that doesn't mean it's meaningless, according to the majority, to say that refusing to blow takes us from an ordinary misdemeanor to a first degree misdemeanor. There's still a consequence to that. And that consequence is that the period of your license suspension increases, as does your prior offense score. So when you get sentenced the next time, if you commit another offense, your prior offense score will be higher. And so any subsequent crimes you commit will be punished more severely. So the majority simply says the way we're interpreting the statute does in fact give meaning to both A and B. So then the majority addresses the Commonwealth and Justice Mundy's point that other offenses, that the title of that provision, other offenses, means that we're talking about something entirely different when we move down to 3803B. That when you add in the new element, the refusal to blow or to give blood, that is something different and isn't governed by 3803A at all. And the majority simply says, no, look, notwithstanding means what it says. 3803A says notwithstanding anything in B, if you're at a second offense DUI, then 6 months is your max, notwithstanding anything in B. It means what it says. And then this is my absolute favorite part of the opinion when we look at whether the specific governs the general. Remember, we talk about the example I kind of came up with as I was doing this tape. No big trucks on the highway, but a 18-wheeler weighing less than 20,000 pounds is permitted. Which of those governs an 18-wheeler with 19,500 pounds? The specific governs the general because they are in conflict. So what do we think about when we say in this particular statute, 3803A says maximum penalty of 6 months for a DUI second offense, but the specific could be taken to say, that's the general rule. The specific might be But if it involves a refusal to take the test, then a first-degree misdemeanor, which takes us up to 5 years. That's the Commonwealth's view of the specific and the general. And since we have a conflict between A and B, the specific is that if you have a first-degree misdemeanor, that's a 5-year penalty. The general rule is, look, for ordinary second offenses, 6 months. The specific is, but with the refusal to take the test, it's first degree. But that's not the only way to draw this diagram. Here's the majority's view. The majority says, sure, we'll give you the specific versus general principle of statutory interpretation. But you've got the diagram in only one of two possible positions. You could say that first-degree misdemeanors involve a 5-year penalty. There's your general rule. First-degree misdemeanors involve a 5-year penalty. And here is your specific rule, except when they involve second offense DUIs. And then they involve a 6-month penalty. That is another perfectly reasonable way to construe this statutory construction canon. You'll hear more about canons of statutory interpretation. It's kind of like theorems from geometry, ways you go about applying or understanding ambiguous legislative terms. This canon of statutory interpretation that says the specific governs the general, well, it just depends in this case how you define the specific and how you define the general. All right, so that is all I have on this particular case. It's a fairly complicated case. As you can see, there's a lot packed into a small number of words. So we'll take this up in class and we'll have a more robust conversation and obviously a more interactive one at that time.